Imagine a bill for, I don't know, $710 just showing up in your mailbox every single day.
Yeah, just out of nowhere.
Right. And, when you call the government to ask why you're being charged, they don't even point to a specific law that says you have to pay it.
Which is the crazy part.
Exactly. Instead, they just say, well, the law doesn't explicitly say we can't charge you, and, our interpretation is reasonable, so pay up.
I mean, it sounds like extortion, honestly.
It really does.
Yeah.
But for 40 years, that exact kind of logic, a hidden legal doctrine, allowed that to govern. Like the air you breathe, the water you drink, the products you buy, basically everything.
Yeah, your whole life, basically.
Right. But today, that rule is completely dead.
It is. It's what I like to call administrative dark matter.
Ooh, I like that term, dark matter.
Because, we like to think of our legal system as this solid, easily readable blueprint. Like you see a speed limit sign, you know the rule.
Sure, 65 means 65.
Exactly. Or you pay your taxes and you see the exact percentage taken out. But when you step into the world of federal regulations, like the actual granular mechanics of how these broad laws are applied to reality, that blueprint just vanishes.
This is gone.
Yeah, it's a vast, invisible universe that dictates our lives, and, well, the foundation of that universe has just fundamentally cracked.
Welcome to this deep dive. Our mission today is to demystify what the end of the Chevron doctrine actually means for you.
Because it seems a lot.
It really does.
Yeah.
For 4 decades, Chevron deference was like the invisible scaffolding holding up the entire modern American regulatory state.
Yeah, it held everything together.
And we're going to explore how this doctrine started as a tool for economic deregulation, why it ultimately fell at the hands of some commercial fishermen, and honestly, the chaotic, fascinating reality of what comes next.
Because, look, this isn't just a story about judges and lawyers arguing in marble rooms. I mean, it is that, but it's really a story about the balance of power in a modern democracy.
Right. Who actually gets to make the rules?
Exactly. We are looking at a massive seismic shift in how power is transferred between the branches of our government, and it's reshaping the landscape in real time.
And we have an incredible stack of sources to help us navigate this shift today. I mean, it's a huge stack.
It's pretty heavy reading.
Oh, yeah. We are pulling from actual Supreme Court opinions, spanning all the way from the original 1984 decision to 2025.
The primary texts.
Right. Plus, we have these deep, really mechanical legal analyses from the University of Chicago Law School and NYU's Tax Law Center.
Which are fantastic resources.
So good. We're also looking at corporate legal bulletins from Taft Law and Holland and Knight, just detailing how businesses are actively adapting to this.
Yeah, the practical side of things.
Exactly. And on top of that, we are tracking official 2025 and 2026 press releases from the EPA, as well as regulatory data from Harvard Law's Environmental and Energy Law program.
It is a really comprehensive stack. And, to truly understand where we are right now, in the aftermath of this massive legal earthquake, we kind of have to understand the pressures that caused the foundation to be laid in the first place.
We have to go back to the origin story.
Yeah, we have to go back.
Okay, let's unpack this. We need to travel back to the late 1970s and early 1980s.
A very different time.
Totally. And the context here is absolutely crucial because, well, the law doesn't just exist in a vacuum, right? It responds to the world around it.
Right, it's reactive.
Exactly. And the American economy back then was really slumping. Under President Jimmy Carter, the country was dealing with this brutal, grinding economic condition called stagflation.
Right, that toxic combination of really high inflation and just agonizingly low economic growth.
Yeah, just the worst of both worlds. And then Ronald Reagan gets elected, and he campaigns on a very specific promise, which is deregulation.
Which was huge at the time.
Huge. The prevailing argument was that the American economy was just being suffocated by this alphabet soup of excessive federal rules.
Yeah, the red tape.
Exactly. If you wanted to, spur capital investment, build new factories, create jobs, you just had to get the federal bureaucracy out of the way.
And the Environmental Protection Agency, the EPA, kind of becomes ground zero for this whole philosophy.
Okay, so what happens at the EPA?
Well, Reagan appoints Ann Gorsuch to lead the EPA, and she comes in with this massive mandate to just streamline everything. She wants to implement something called the bubble concept under the Clean Air Act.
The bubble concept.
Yeah, specifically for what were designated as non-attainment areas.
Let's define that real quick, because non-attainment areas sounds like, I don't know, super boring bureaucratic jargon.
It really does.
But it just means a part of the country that is actively failing to meet national air quality standards.
Yeah.
Like the air is literally too dirty to be safe, usually around heavy industrial zones.
Right, exactly. So to understand why this bubble concept was so revolutionary, you have to look at the mechanics of how the EPA was operating before Gorsuch even arrived.
Okay, set the scene for us.
Let's visualize a massive manufacturing plant in the Rust Belt, right? It's not just one building. It's this sprawling complex with dozens of different smokestacks, exhaust vents, combustion units.
It's a massive footprint.
Yeah. And under the strict reading of the Clean Air Act at the time, every single one of those individual emission points was treated as a distinct individual stationary source of pollution.
Wait, so every single pipe?
Every single pipe. So if a company wanted to upgrade or modify just one of those pieces of equipment, say, I don't know, replacing a single aging boiler with a slightly newer one, they had to go through this grueling, insanely expensive permitting process for that one specific smokestack.
Well, I mean, that sounds like a nightmare.
It was agonizing. It required massive environmental impact studies, public hearings, technological mandates. It took forever.
So what did the companies actually do?
Well, they just wouldn't upgrade.
Seriously?
Yeah, they would just keep running the old, dirty, totally inefficient equipment until it literally fell apart. Because getting the permit for the new equipment was just too much of a headache.
Wow, so the strict regulation was actually creating a massive disincentive for modernization.
Exactly. It's the ultimate law of unintended consequences. So, Ann Gorsuch and the EPA, they decide to fundamentally change the definition of the word source within their own regulations.
I mean, how do they change it?
Well, instead of looking at every individual smokestack, they mentally drew a giant imaginary bubble over the entire factory site.
Just one big dome over the whole thing.
Right. And the logic was really simple. I mean, the atmosphere doesn't care which specific pipe the pollution comes from.
Right, it all ends up in the same sky.
Exactly. It only cares about the total volume of pollution entering the air from that geographic location. So under this new rule, as long as the total emissions coming out of that single giant bubble didn't increase, the company could modify, upgrade, or replace the equipment inside the bubble without triggering that massive permitting process.
Oh, I get it. So it's basically like giving a teenager a monthly clothing allowance of $100.
Okay, I like this.
Right. Like instead of line itemizing every single pair of socks or t-shirt they buy and making them ask for permission every single time they walk into a mall, you just draw a bubble around the $100 and say, manage it yourself.
Exactly.
As long as you don't go over the $100 limit, I don't care how you distribute the funds inside that bubble.
That is a perfect analogy. And, taking that allowance metaphor a step further, the EPA argued that companies would use this new internal freedom to actually buy better, more efficient, and ultimately less polluting equipment.
Because it saves them money in the long run.
Right. So they argued it was a win for economic growth because it spurred investment, and a win for the environment because it modernized these old, dirty plants.
Okay, but I'm guessing environmental advocacy groups did not see it as a win.
No, they did not. Not at all.
Yeah, the Natural Resources Defense Council, the NRDC, they look at this new bubble rule and completely balk.
They hated it.
Because they point to the actual text of the Clean Air Act, which specifically says the EPA has to regulate new or modified major stationary sources.
The exact wording matters.
Right. And the NRDC argues that you can't just redefine the word source to mean an entire sprawling industrial complex when the explicit goal of the law, especially in these dirty air areas, is to force incremental improvements.
Yeah, you can't just shuffle the status quo around under a dome.
Exactly. So the NRDC sues the EPA to stop the bubble concept.
And this is where the corporate interests really step in. Chevron, the massive multinational energy corporation, they actually intervene in the lawsuit on the side of the EPA.
Of course they do.
Because oil refineries are the exact type of sprawling complexes that desperately wanted this regulatory flexibility.
Makes total sense.
So this bitter legal fight over the definition of a single word, just the word source, it climbs all the way up the judicial ladder until it reaches the Supreme Court in 1984.
In the landmark case, Chevron v. NRDC.
Yes. And this is the moment the earth basically shifts beneath the American legal system.
So what happens?
The Supreme Court issues a unanimous 6-0 decision. It was written by Justice John Paul Stevens. And the court basically looks at the massive, complex text of the Clean Air Act. They look at the legislative history, and they essentially just throw up their hands.
They just give up.
Kind of. They say, well, Congress didn't explicitly define what stationary source means in this highly specific, highly technical context. The statute is ambiguous.
And that finding of ambiguity is everything. That is the spark that ignited a 40-year legal era.
It really was. Because the statute was ambiguous, Justice Stevens established a two-step legal test that would go on to basically rule administrative law for the next 4 decades.
The famous Chevron two-step.
The Chevron two-step. So step 1, a judge must ask, did Congress speak directly to the precise question at issue?
Okay.
Like, if the statute is crystal clear, if it says a source is a single pipe, well, that's the end of the inquiry. The agency has to follow the strict letter of the law.
But statutes passed by Congress are almost never crystal clear.
Almost never.
Especially when they're trying to regulate complex science or, national economies. They use broad, messy language.
Exactly. Which leads to the critical part, step 2. If the statute is silent or ambiguous on the specific issue, the court cannot just impose its own interpretation of what the law should mean.
Wait, really? The judges just back off?
Yes. The only question for the judge at that point is whether the agency's interpretation is based on a permissible or reasonable construction of the statute.
So if the EPA's bubble concept is just a reasonable way to read the messy law, the judges have to back off.
They must defer to the agency. That is the absolute birth of Chevron deference. The courts are legally obligated to bow to the expertise of the executive branch as long as the executive branch isn't doing something wildly irrational.
Wow. And Justice Stevens had a deeply philosophical rationale for this, didn't he?
He did. He argued that when a law is ambiguous, filling in those blanks isn't really a legal exercise anymore. It's a policy choice. It involves balancing competing societal interests, like weighing the need for economic growth against the desire for environmental purity.
So it's not about reading a dictionary. It's about making a governance decision.
Exactly. Stevens essentially laid out a structural argument for American democracy. He noted that judges are not experts in environmental science, toxicology, or industrial engineering.
No, they're lawyers.
Right. But, more importantly, federal judges are appointed for life. They are unelected. They don't have a constituency.
That's a huge point.
Agencies, on the other hand, are staffed by scientists and experts, and they answer to the President of the United States, who is elected by the entire country.
Right.
Therefore, Stevens argued, resolving these ambiguous policy gaps belongs to the political branches of government, which can actually be held accountable at the ballot box, not to unelected judges in robes.
I mean, that is an incredibly persuasive piece of logic. You want the people who actually answer to the voters making those really tough calls.
You do. But, and this is the crazy part, there is a massive historical irony here that completely shapes the modern political landscape.
Let's hear it.
The Chevron doctrine was born as a massive victory for the conservative deregulatory movement.
Right. It was the Reagan administration fighting to loosen environmental rules to help corporations.
Exactly. And the Supreme Court handed them the ultimate legal shield to do it. But over the next 40 years, the political polarity of that doctrine completely flipped upside down.
It was a total inversion. What started as this mechanism to shrink the government morphed into the primary engine for expansive, progressive administrative power.
Yeah, it really did, because as the decades went on, Congress became increasingly gridlocked.
Right. They stopped passing highly detailed, comprehensive legislation.
So Democratic administrations who couldn't get new laws through Congress began utilizing the ambiguity in old statutes to pass sweeping new regulations.
We're talking labor rights, greenhouse gas emissions, consumer financial protection, public health.
All of it. And every single time a corporation or an industry group sued to stop these massive new regulations, the federal agencies would just walk into court, hold up the Chevron shield and say, well, the law from 1970 is ambiguous, our modern interpretation is reasonable, and under the Supreme Court's own precedent, you have to defer to us.
And the lower courts just adhered strictly to that precedent, right?
Oh, strictly. They cited Chevron thousands upon thousands of times to uphold agency power. It became the bedrock of the modern administrative state.
So federal agencies knew that as long as they could articulate, just a plausible reading of a vague law, they had immense power to reshape the American economy.
Exactly. The very tool that conservatives cheered and fought for in 1984 became the exact tool they spent the next 2 decades desperately trying to destroy.
That is wild.
The conservative legal movement, which had spent years championing judicial restraint, suddenly realized that if they ever wanted to roll back the sprawling administrative state, they had to pop the Chevron bubble.
They needed the perfect case.
They needed a perfect case to demonstrate that deference had gone way too far.
And that perfect case didn't come from a massive oil refinery or a Wall Street bank, did it?
No, it did not. It came from a small, family-owned industry navigating the cold, choppy waters of the Atlantic Ocean.
Let's fast forward from 1984 to June 28, 2024. The Supreme Court hands down the decision in Loper Bright Enterprises v. Raimondo.
Yes, and the mechanics of this case highlight exactly why the legal system turned on Chevron.
So what's the story with Loper Bright?
Well, it started with a group of commercial fishermen who harvest Atlantic herring off the coast of New England.
Okay, tough job.
Very. And they operate under a federal law called the Magnuson-Stevens Fishery Conservation and Management Act.
Quite mouthful.
Yeah. Under this act, the National Marine Fisheries Service, which is a federal agency, promulgated a rule requiring these fishing boats to carry federal observers on board.
So to be clear, the logic of the observers is pretty straightforward, right? You want federal monitors on the boats to count the catch, track the bycatch, and ensure the fisheries aren't being depleted.
Exactly.
Monitoring overfishing is a totally standard regulatory goal.
It is. But the agency ran into a massive bureaucratic wall. Congress hadn't actually appropriated enough money to pay the salaries of all these federal monitors.
So they had a mandate, but no budget.
Right. So the agency got creative with an ambiguous statute. They issued a rule mandating that the fishermen themselves had to pay the daily wages of the federal observers riding on their own boats.
Wait, they made the fishermen pay for their own regulator?
Yes. We are talking about roughly $710 a day.
Oh my gosh. For a massive commercial trawling corporation, maybe that's just a rounding error, but for a small, family-owned herring boat,
It's devastating.
that is $700 a day. It could literally eat up their entire profit margin for an excursion. It forced them to pay for the privilege of being regulated.
Exactly. So the fishermen sued. They pointed to the Magnuson-Stevens Act and argued that absolutely nowhere in the text of the law did Congress explicitly grant the agency the authority to force private citizens to pay the salaries of federal employees.
I mean, it sounds unprecedented.
It was an unprecedented financial extraction, but the lower courts looked at the case and simply applied the Chevron two-step.
Let me guess.
Yeah.
They said the statute is ambiguous.
Yep. They said, well, you're right that the statute doesn't explicitly authorize it, but it doesn't explicitly forbid it either. It's ambiguous. And the agency's interpretation that they can pass on the costs is arguably reasonable to fulfill their conservation mandate.
Therefore, fishermen, you have to pay.
Exactly. But the fishermen refused to accept that logic. They appealed all the way up to the Supreme Court.
And this is where it all comes crashing down.
Yes. Chief Justice John Roberts, writing for a 6-2 majority, drops an absolute legal nuclear bomb. He doesn't just side with the herring fishermen on the specific fee, he completely, unequivocally overrules Chevron v. NRDC.
He just erases 40 years of precedent from the books.
Gone.
It's so rare for the Supreme Court to so bluntly overturn a foundational precedent like that.
Yeah.
How did Chief Justice Roberts justify tossing out 40 years of established administrative law? Like, what was the mechanical, legal reasoning behind the execution?
Well, Roberts dug deep into the historical architecture of the federal government, specifically a foundational piece of legislation from 1946 called the Administrative Procedure Act, or the APA.
Now, the APA is essentially the constitution for how federal agencies are supposed to operate, right?
Right.
It was passed right after World War II, when the modern alphabet soup of federal agencies was really exploding.
Exactly. The New Deal and the war effort had created this massive bureaucracy, and Congress felt the need to write a strict rule book for how these agencies could make rules and how courts should review them.
Right.
And Roberts pointed specifically to Section 706 of the APA. That section explicitly commands that courts, the judicial branch, shall decide all relevant questions of law, interpret constitutional and statutory provisions, and determine the meaning of an agency action.
So Roberts looks at the plain text of the 1946 APA and says that Chevron was essentially an illegal abdication of judicial duty from the very start.
That's his argument.
It forced judges to hand over their core constitutional job interpreting what the law means to the executive branch.
Right. He argued that the whole premise of the Chevron two-step was based on a flawed legal fiction. Chevron operated on this presumption that if a statute was ambiguous, Congress implicitly intended for the agency to fill in the blanks.
And Roberts dismantled that presumption.
Completely. He wrote that ambiguity isn't some secret coded delegation of power to an agency. Ambiguity just means the law is messy or hastily written or applying to a situation Congress didn't foresee.
Like the internet or climate change.
Exactly. And when the law is messy, Roberts says it is the court's fundamental job to clean it up and figure out the best, most accurate reading of the statute using traditional tools of legal interpretation.
A judge cannot put a thumb on the scale for the government just because the government is the one doing the regulating.
Precisely. It is a massive reclamation of power by the judiciary. But, as you can imagine, the liberal wing of the court was fiercely, passionately opposed to this shift.
Yeah, I'm looking at the dissent written by Justice Elena Kagan, which Sotomayor joined. Jackson was recused on one of the consolidated cases, and Kagan doesn't hold back at all.
She does not.
She basically calls this a breathtaking power grab by the judiciary. She writes about the hubris of judges.
Kagan's dissent is deeply rooted in the exact same practical logic that Justice Stevens used back in 1984. She argues that the modern world is unfathomably complex.
Right.
Federal agencies employ thousands of scientists, epidemiologists, toxicologists, and economists who spend their entire lives studying niche, highly technical fields.
And judges, well, they have law degrees.
Right. They are experts in legal syntax and historical precedent, not synthetic biology.
She literally writes, "A rule of judicial humility gives way to a rule of judicial hubris."
It's a powerful line.
But there is an incredibly fascinating, almost Shakespearean historical wrinkle to this entire debate that we have to mention.
Oh, yes. The Gorsuch connection.
Yes, one of the loudest, most consistent voices against Chevron leading up to this exact moment was Justice Neil Gorsuch.
His history with this doctrine is central to its downfall. Back in 2016, when he was a judge on the 10th Circuit Court of Appeals, Gorsuch wrote a famous, highly influential opinion predicting and advocating for this exact reversal.
What does he say?
He argued that agencies shouldn't be allowed to just alter the law on a whim, depending on who is in the White House. He famously wrote that we managed to live with the administrative state before Chevron, and we could do it again.
And the irony, the absolute incredible irony, is that Neil Gorsuch is the son of Ann Gorsuch.
Yeah.
The very EPA administrator who championed the bubble concept in the early 1980s that gave birth to the Chevron doctrine in the first place.
It is wild.
The mother built the legal empire to deregulate the environment, and her son helped tear that exact same empire down 40 years later to achieve the exact same deregulatory goal. You simply cannot write better legal drama than that.
You really can't. It is an incredible full circle moment in American legal history. But, to get back to Justice Kagan's dissent for a second, she brings up a really vital, practical tension that goes far beyond family legacies.
Right, because this is where the theoretical legal arguments hit reality. Let's look at a hypothetical.
Okay, let's do it.
If a statute involves deeply complex science, let's say Congress passes a broad law saying the EPA must ensure the groundwater is safe from synthetic chemicals.
Very common type of phrasing.
Right. That word safe is wildly ambiguous. Now, a novel, highly toxic forever chemical is discovered. The EPA toxicologists determine that anything over 2 parts per million is unsafe, and they write a rule banning it. Under Loper Bright, how does a judge, whose expertise is reading 18th century common law and parsing statutory text, claim to understand the acceptable toxicity threshold of a synthetic chemical better than the EPA scientist who has spent 20 years in a lab?
This raises an important question, and it is the absolute core of the post-Chevron anxiety across the government.
Yeah.
Under Loper Bright, courts are now required to exercise what Roberts calls independent judgment, meaning the power to define what is safe or what is reasonable or what constitutes an endangered species under an ambiguous statute has dramatically shifted away from the executive branch and placed squarely into the lap of the judiciary.
So the judge literally becomes the ultimate decider of science.
Well, not exactly. The judges still take testimony from experts. They read the massive scientific briefs submitted by the agency and by the corporations challenging the rule.
Okay, so they're reading the science.
Yes. But the judge is the ultimate arbiter weighing that evidence. The critical difference is that the agency no longer walks into the courtroom with an automatic advantage.
Right.
They don't get the benefit of the doubt anymore. The thumb has been entirely removed from the scale.
Which instantly opens the floodgates. I mean, the moment the Loper Bright decision was handed down, Corporate America and advocacy groups realized that thousands of regulations that had been protected by the Chevron shield for decades were suddenly naked and vulnerable to attack.
Oh, completely.
We move into the immediate aftermath, what our sources actually describe as a tsunami of litigation.
It was an immediate seismic event in the legal world. According to the analyses we are looking at, including reports from the law firm Pearl Cohen and tracking data from the University of Chicago Law School, by late just months after the decision, over 150 lawsuits challenging federal regulatory authority were filed almost instantly.
150, that is a gold rush for litigators.
It was. We are talking about immediate, aggressive challenges to environmental climate rules, labor union regulations, workplace safety standards, public health mandates, consumer financial protections. Basically, every rule that relied on a slightly ambiguous statute was suddenly a target.
And it wasn't just Loper Bright that caused this massive spike, was it? There was a second Supreme Court decision handed down around the exact same time that acted like a massive force multiplier.
Yeah, it's the kicker to this whole situation, a case called Corner Post.
Let's explain the mechanics of corner post, because this is where the legal strategy gets truly wild for anyone listening.
It does.
The case dealt with the statute of limitations for challenging a federal regulation. Usually under the Administrative Procedure Act, a citizen or a company has 6 years to sue the government after a final rule is published.
Right, and that 6-year window was considered an absolute bedrock of administrative stability.
Because you need finality.
Exactly. The logic was that if an agency makes a rule in 2010, the window to sue closes in 2016. After that, the industry adapts, investments are made, and the rule just becomes a permanent fixture of the regulatory landscape.
But corner post fundamentally changed the starting line for that 6-year clock.
How so?
The Supreme Court ruled that the clock doesn't start ticking when the rule is written and published in the Federal Register. Instead, the clock starts ticking when the plaintiff is actually injured by the rule.
Meaning when the government actually enforces the regulation against a specific entity?
Yes. The implications of that are staggering. It means that if a brand new company is formed in 2025 and they enter an industry that is governed by a regulation written back in 1995, that new company is experiencing the injury of that regulation for the first time in 2025.
Wow.
Therefore, their specific 6-year clock to sue starts the exact day they open their doors.
I mean, it's like a sleeper agent company.
Yes. A trade association could literally spin up a brand new LLC tomorrow, enter a regulated market, and instantly trigger a fresh 6-year window to sue to overturn a regulation that has been on the books unchallenged for 30 years.
That is exactly the mechanism. Professor Jennifer New at the University of Chicago Law School pointed out this exact dynamic.
What did she say?
She noted that when you combine the death of Chevron deference, meaning old rules are no longer protected by ambiguity with the newly opened time windows from Corner Post, you have a recipe for challenging almost the entire historical catalog of the American administrative state.
No rule is ever truly safe from litigation.
None.
So what does a federal agency even do in that environment? I mean, if you are the head of the EPA or the Securities and Exchange Commission, and you know that any binding rule you write is going to be immediately sued and judged by a court that absolutely refuses to defer to your expertise, how do you actually govern the country?
You change tactics. You adapt to the terrain. Our experts at UChicago noted a massive systemic shift across the executive branch from agency rulemaking to agency guidance.
Break down the legal distinction there. Why is guidance safer than a rule?
Well, a rule goes through a formal, legally binding process called notice and comment. Once it's finalized, it has the force of law.
Meaning if a company breaks a rule, the government can fine them or shut them down.
Exactly. But because rules are legally binding, they are subject to immediate, fierce lawsuits under the APA. Agencies are now terrified to lay down those strict legally binding rules because they know the Loper Bright standard makes them highly vulnerable to being struck down by a skeptical judge.
So instead of making a hard rule, they issue a guidance document.
Yes. A guidance document is essentially just a memo from the agency. It basically says, hey, industry, here's how our agency currently interprets this ambiguous law, and here's how we suggest you act to avoid our scrutiny.
But it doesn't have the force of law.
Right. You technically can't be fined just for violating guidance. But practically, companies rely heavily on guidance because they want to stay in the agency's good graces and avoid triggering a broader, grueling investigation into their practices.
It's regulatory soft power.
Precisely. The agency hopes that companies will voluntarily comply with the memo to avoid friction, bypassing the need for a legally binding rule that will just end up in court anyway.
Because when agencies do try to flex their muscle and make hard rules, they are just getting hammered by the courts right now.
Hammered.
We can look at the Taft Law Bulletin we have in our sources for a perfect example of this. The Federal Trade Commission, the FTC, tried to institute a sweeping, nationwide ban on non-compete clauses in employment contracts.
It was a massive deal.
Huge deal. A non-compete clause being the legal trap, where a company says to an employee, if you quit, you can't work for our competitors for 2 years.
Right.
The FTC argued these clauses stifle wage growth, reduce innovation, and unfairly trap workers in bad jobs, so they wrote a formal rule banning them across the board.
But a federal court in Texas struck the rule down almost immediately, and the judge explicitly cited Loper Bright in the decision.
Wow.
Yeah. The judge ruled that the FTC lacked the clear, explicit statutory power from Congress to make such a massive economy-wide ban. Under the old Chevron regime, the FTC might have successfully argued that their mandate to prevent unfair methods of competition was ambiguous enough to cover non-competes, and the court probably would have deferred.
But post-Chevron.
Post-Chevron, the judge looked at the text, said, I don't see the word non-compete anywhere in here, and killed the rule.
And Taft's Law points out in their corporate briefings that this vulnerability goes far beyond high-profile labor issues. It trickles all the way down to everyday consumer products.
Yeah, things you wouldn't even think about.
Right. The Consumer Product Safety Commission, the CPSC, they issue highly technical rules for everything from the lithium-ion battery safety standards of e-bikes to the manufacturing tolerances for smoke detectors and bicycle helmets.
And Taft Law notes that without Chevron deference, the CPSC is suddenly incredibly vulnerable.
How so?
Well, if an e-bike manufacturer overseas feels that a new battery testing standard is too expensive or too burdensome, they don't have to just accept it anymore.
They can fight it.
They can file a lawsuit arguing the CPSC overstepped its ambiguous statutory mandate regarding what constitutes an unreasonable risk. And a judge, acting as an independent arbiter without deferring to the CPSC engineers, might just agree with the corporation and strike the safety standard down entirely.
Which introduces a terrifying geographical dynamic. Does this mean we are entering a Wild West of forum shopping?
It is a huge concern.
I mean, if you're a massive multinational corporation and you want to kill a national safety standard, you don't just file your lawsuit in a random court.
No, you are very strategic.
You scour the country, find one sympathetic federal judge in one specific federal district who has a known anti-regulatory textualist philosophy, file your lawsuit in their courtroom, and have them nuke a safety standard for the entire United States.
That is the exact fear keeping agency lawyers awake at night. If courts are making independent judgments without deferring to a centralized federal agency, the law could literally mean something different in Texas than it does in California.
That's chaos.
It is. And we are currently watching a massive high-stakes test case for this exact phenomenon right now, FDA v. R.J. Reynolds Vapor Company.
Okay, let's look at that case. An e-cigarette manufacturer, R.J. Reynolds Vapor, was denied market access for their flavored vaping products by the Food and Drug Administration. The FDA cited public health risks, particularly to minors.
Right.
Now, normally, a company would sue in the federal circuit where they are headquartered or where the agency is based in D.C.
But R.J. Reynolds didn't do that.
No, they did not. Instead of suing in their home circuit, they strategically joined up with a handful of local gas stations in convenience stores in Mississippi.
Oh, my Mississippi.
Because that allowed them to file the lawsuit in the Fifth Circuit Court of Appeals. And the Fifth Circuit is widely known in the legal community for being deeply skeptical of federal administrative agencies and highly favorable to corporate challenges.
It's blatant strategic forum shopping.
The FDA completely recognized this and is actively taking the issue to the Supreme Court, arguing that corporations shouldn't be allowed to just manipulate the judicial map to find judges willing to veto national health standards.
Yeah, how the Supreme Court rules on this specific R.J. Reynolds case will absolutely determine just how chaotic and geographically fragmented this new era of administrative law will become.
It really paints a very bleak picture for the power of the federal government. But we need to pause here and inject some critical nuance into this conversation.
We definitely do.
Because if you only listen to the most vocal critics, it sounds like total anarchy. Like agencies are paralyzed, courts are striking down every rule, corporations are just running wild.
But that's not the whole truth.
Right. According to the deep analysis from our sources at the NYU Tax Law Center, the sky is not actually falling.
No, it's not. Let's break down the NYU Tax Law Center's argument, because they strongly push back against this cataclysmic narrative.
What do they say?
They point out a fundamental truth, which is that Loper Bright killed automatic deference to ambiguity, but it did not destroy the traditional tools of statutory interpretation. It didn't strip agencies of all their power.
It's a crucial distinction.
Exactly. The NYU authors explain that Congress can still constitutionally delegate discretionary authority to federal agencies. They just have to do it explicitly now.
So if Congress writes into a law, the Secretary of the Treasury shall determine the appropriate accounting method for this specific corporate deduction, the courts still have to respect that explicit delegation.
Yes. Loper Bright simply says that courts can no longer use ambiguity as an excuse to invent delegation where none exists.
So the court still has to use its normal toolbox. A judge looks at the text of the law, the context of the surrounding statutes, the historical purpose of the legislation to figure out what Congress actually meant.
Exactly.
And if the judge determines that the absolute best, most accurate reading of the law is that Congress wanted the agency to make the technical call, the agency still wins the case.
Yes, they do. And there is another incredibly important legal concept that survived the death of Chevron. It's an older form of deference that doesn't rely on blind obedience. It's called Skidmore deference, named after a Supreme Court case from 1944.
Skidmore deference. How does that work mechanically compared to Chevron?
Think of it as the difference between a boss ordering you to agree with them versus an expert persuading you with data.
Oh, I like that.
Under Chevron, the agency was the boss. They told the judge, the law is ambiguous, our rule is reasonable, you must agree with us by law.
And the judge had no choice.
Exactly. Under Skidmore deference, the agency acts like a highly credentialed expert witness.
Okay, so a court can look at an agency's interpretation of a messy law and basically say, you guys are the subject matter experts. You've been regulating this industry for 50 years. You have thousands of pages of scientific data, and your argument is incredibly thorough and persuasive.
Right. We, the judges, aren't legally forced to agree with you, but the sheer weight of your expertise convinces us that your interpretation is the correct one.
So it's the power of persuasion rather than the power of a legal mandate. The agency has to actually earn the victory in court.
Precisely. And the federal tax code is the perfect, real-world example of this dynamic in action.
Oh, taxes are always a great example of complexity.
The NYU authors highlight that the IRS and the Treasury Department are constantly dealing with incredibly complex, highly lucrative issues. Massive corporations and billionaires are always employing armies of lawyers to find loopholes and game the tax system.
Right. Because of that constant cat-mouse game, Congress has historically given the Treasury broad, explicit statutory authority to write highly detailed rules preventing tax evasion.
Exactly. For example, look at the recent Inflation Reduction Act. It includes massive new provisions like the Corporate Alternative Minimum Tax or the CAMT.
Which is designed to ensure billion-dollar corporations pay at least a 15% tax rate regardless of their deductions.
Right. It also includes incredibly complex rules for the new clean hydrogen production tax credit.
And the Treasury Department still has the absolute authority to write the intricate regulations governing the CAMT and the hydrogen credits.
Yes, Loper Bright didn't erase that. The difference now is the posture they take in court.
How so?
If a massive corporation sues the IRS over how the CAMT is calculated, the IRS can't just walk into court, shrug, and say, well, the tax code is confusing, our rule is reasonable, case closed.
They can't do the two-step.
No. The IRS has to go into court and affirmatively prove that their specific reading of the tax code is the absolute best reading. They have to show their mathematical and legal homework.
So, using a metaphor, Loper Bright didn't take away the agency's car keys. It just stopped the courts from automatically assuming the agency is the best driver on the road simply because they have a government badge.
That is a great way to put it.
But isn't proving you're the best driver highly subjective for a judge? Like, what makes one complex tax interpretation the best in the eyes of a judge who isn't an accountant?
Well, if we connect this to the bigger picture, it is inherently subjective. But what the actual data shows, and this is a critical point highlighted by the NYU piece, citing recent Department of Justice reports, is that lower courts are actually upholding agency actions at roughly the same rate post-Chevron as they were before the doctrine fell.
Wait, really? So the apocalypse hasn't happened?
Not in the win-loss columns, no.
That's fascinating.
The agencies are just adapting to the new rules of engagement. They are writing much more detailed regulations from the start. They are providing immensely thicker scientific and economic records. They are anticipating the legal challenges and making better, more airtight textual arguments.
So when the agency puts in the work to prove it is the best driver, the judges are still letting them drive the car.
Exactly. They just have to work harder for it.
Okay, so the agencies are learning how to defend their rules better in court. But while the career scientists and lawyers are trying to prove they are good drivers, the political leadership of these agencies is completely changing the destination.
Oh, absolutely.
We need to look at how the shifting political environment is weaponizing this new legal reality. Let's examine the political pendulum swing of 2025 and 2026.
And as we dive into this, it is essential to frame what we are doing here.
Yes, we really need to emphasize this for everyone listening. We are completely impartial here.
Right. We are not taking sides or endorsing any political viewpoints. We are looking at these executive actions purely as a mechanical analysis of administrative law.
We are just looking at government press releases and academic trackers to understand how the executive branch is aggressively utilizing the post-Chevron landscape. We are just the messengers.
Exactly. So let's look at July 29th, 2025. The Environmental Protection Agency, now operating under Administrator Lee Zeldin in the newly returned Trump administration, puts out a massive, highly consequential press release.
What did it say?
They announce a formal proposal to completely rescind something called the 2009 endangerment finding.
The 2009 endangerment finding? This is huge. It is arguably the single most important document in modern environmental law.
It was the foundational pillar of the Obama-era EPA's entire climate policy.
Because in 2009, following a Supreme Court directive, the EPA officially issued a scientific and legal finding declaring that greenhouse gases, specifically carbon dioxide, accumulate in the atmosphere and endanger the public health and welfare of current and future generations.
And by making that specific formal finding of endangerment, it legally triggered the EPA's authority under Section 202 of the Clean Air Act to start aggressively regulating carbon emissions from cars, trucks, and eventually power plants.
It was the domino that started the entire climate regulation cascade.
And the 2025 EPA press release explicitly targets that history. The Zeldin EPA states that this single 2009 finding was utilized by previous administrations to justify over $1 trillion in sweeping economic regulations over the years.
$1 trillion.
Yeah. That includes the Biden administration's aggressive emission mandates that were designed to force the automotive industry's transition toward electric vehicles.
And the Trump EPA's argument for rescinding the endangerment finding relies fundamentally on the new Loper Bright reality, right?
It does. Their legal argument is that you cannot creatively interpret a broad, ambiguous environmental law written in the 1970s when smog was the main concern to regulate a complex global economy shifting issue like climate change today.
Because Congress didn't say the words climate change in the 70s.
Right. The EPA's argument is that Congress never explicitly textually authorized the regulation of greenhouse gases in the Clean Air Act.
Therefore, the agency argues, without the Chevron shield to protect that expansive, creative interpretation of the 1970s text, the entire regulatory framework built on top of the endangerment finding is legally invalid.
The executive branch is literally using the Supreme Court's mandate for strict textualism to tear down its own agency's historical work.
It's mind-blowing. And the press release is full of economic justifications for this reversal. It includes statements from the head of the Small Business Administration, Kelly Loeffler, claiming this massive regulatory rollback will save small American businesses an estimated $170 billion in compliance costs.
Huge numbers.
It also includes quotes from the American Trucking Association praising the end of what they called an impossible electric vehicle mandate that would put the freight industry on a path to economic ruin.
But it wasn't just vehicle emissions on the chopping block. We have tracking data from Harvard Law's Environmental and Energy Law program regarding power plants in early 2026.
Yes, Harvard Law tracked the dismantling of the MATS rule.
MATS stands for the Mercury and Air Toxic Standards. This is a highly technical rule that limits exactly how much mercury, acid gases, and other severe neurotoxins coal and oil-fired power plants are legally allowed to emit into the atmosphere.
And the Biden administration had recently updated and significantly tightened these toxic standards in 2024, citing new public health data and the availability of better scrubber technology.
But in February 2026, the Trump EPA finalized a rule repealing those strict 2024 Biden updates entirely, reverting the emission limits back to the much looser, less expensive standards from 2012.
And the legal justification, again, weaves in this new overarching philosophy. Without judicial deference, agencies shouldn't be pushing the outer boundaries of their ambiguous statutory authority to impose massive billion-dollar compliance costs on the energy industry.
Exactly.
The mechanics of what is happening here are truly staggering when you step back and look at it. We are watching the executive branch utilize a Supreme Court decision, a decision that was explicitly designed by the judicial branch to limit the power of the executive branch, as the precise, unassailable legal justification to dismantle the executive branch's own historical regulations.
It's quite a maneuver.
They're essentially telling the courts, you told us we don't have the inherent power to creatively interpret the law. Therefore, we are eagerly stripping all these old rules away, and you can't stop us.
It is a brilliant, aggressive utilization of the new legal terrain, but it raises a profound concern about the stability of the American system.
How so?
Well, under Chevron, it was actually quite legally difficult for a new president to come in and just reverse course on major regulations. To undo a rule, the new administration had to go into court and prove that the old rule was actively unreasonable, which is a very high legal bar to clear.
But without deference, a new agency director can just look at a statute with fresh eyes, apply their own independent textual judgment, declare that the old rule was legally wrong from the start, and erase it.
Exactly.
What happens when the political pendulum swings back? If an administration can use the lack of Chevron deference to rapidly tear down old rules in 2026, what happens in 2028 or 2032 when a new administration tries to aggressively rebuild them? Are we just going to get severe regulatory whiplash every 4 to 8 years?
That is the ultimate fear for the American economy. Capital markets rely on predictability.
Right.
If you are building a billion-dollar power plant or designing a new line of automobiles that takes 5 years to engineer, it is incredibly difficult to plan for the future when the regulatory environment is a pendulum swinging wildly from one absolute extreme to the other with no judicial anchor to stabilize it.
But just as everyone in the legal and corporate worlds was getting used to this new, brutal, deference-free reality, the Supreme Court delivered a massive plot twist.
They really did.
Less than a year after Loper Bright supposedly killed agency deference forever, we get the 7-county decision in May 2025.
7-County Infrastructure Coalition v. Eagle County. This case is a perfect, complex example of how the law is never as simple as a newspaper headline.
It proves that deference didn't actually die, it just relocated.
Yes.
Let's lay out the facts of the case, because the geography and the stakes here really matter. The case involves an 88-mile railway proposed to be built in the rugged terrain of Utah.
Okay.
The goal of this railway was to connect the isolated Uinta Basin, which is rich in waxy crude oil, to the national freight network. To build a massive infrastructure project like this, the coalition needed formal approval from a federal agency called the Surface Transportation Board.
And whenever the federal government approves a major landscape-altering project like an 88-mile oil train, it legally triggers NEPA, the National Environmental Policy Act.
Which is essentially the look-before-you-lead law of the federal government.
Exactly. It requires the approving agency to produce a massive, highly detailed document called an Environmental Impact Statement, or an EIS.
An EIS is not a quick memo. It's often hundreds or thousands of pages detailing exactly how a project will affect the local environment, the water, the wildlife, the air quality.
In this case, environmental advocacy groups sued to stop the railway. They argued that the Surface Transportation Board's environmental impact statement was fundamentally legally flawed.
Why?
Because the agency only studied the environmental impact of the 88 miles of train track itself. The environmentalists argued you can't look at a train track in a vacuum. The only reason the train is being built is to move oil.
Right, it's an oil train.
Therefore, they argued, the agency was legally required to analyze the environmental impact of the upstream oil drilling that the train would facilitate in Utah, as well as the downstream environmental impact of refining that crude oil at the massive refineries down on the Gulf Coast.
And a lower federal court actually agreed with the environmentalists, ruling that the EIS was inadequate and halted the entire multi-billion-dollar project.
But the developers appeal, and the case lands at the Supreme Court. And Justice Brett Kavanaugh writes an 8-0 unanimous decision reversing the lower court and allowing the project to proceed.
But the shocking part of this case isn't the outcome, right? It's the specific legal language Justice Kavanaugh used in his opinion.
Right. Kavanaugh writes that under NEPA, agencies are owed substantial judicial deference.
Wait a second. The Supreme Court just spent an entire year and caused massive national upheaval, declaring that deference to agencies was a violation of the Constitution and the Administrative Procedure Act.
Yeah.
How is Kavanaugh writing that agencies get substantial deference less than a year later?
It sounds like a total contradiction, but here is the crucial razor-thin legal distinction the court is drawing, and it defines the new era we live in.
Okay, lay it on us.
Loper Bright killed deference for questions of law, meaning if a court is interpreting what the specific words in a statute actually mean, the judge has the final say. But the Supreme Court classifies NEPA as a purely procedural statute.
Procedural, meaning it doesn't mandate an outcome.
Yeah.
NEPA doesn't say you cannot build the train if it harms a bird. It just says you must write a report about the bird before you build the train.
Exactly, because it dictates a process of writing a report, deciding exactly how much scientific detail goes into that report, or where to draw the geographic line on what environmental effects to study is not a question of law.
Okay.
According to the Supreme Court, it is a question of fact.
And the courts still believe agencies are the ultimate experts on facts.
Precisely. The Supreme Court ruled that agencies still retain massive deference when making factual, procedural determinations.
So they get to decide the boundaries of the facts.
Right. Furthermore, Kavanaugh ruled on the specific bounds of the agency's authority. He noted that the Surface Transportation Board only has regulatory authority over the train itself. They have zero legal authority over the oil wells in Utah and zero authority over the refineries in Texas.
Therefore, they cannot be forced to study the downstream or upstream effects of facilities they don't regulate.
Exactly.
Hold on, let me make sure I have this straight. Interpreting a vague word in a pollution statute is a question of law where the judge reigns supreme with zero deference to the agency.
Yes.
But deciding exactly how many hundreds of pages to write about the environmental impact of a massive oil train and deciding to ignore the oil it carries is a question of fact where the agency is owed substantial deference by the judge.
Yes.
Isn't the line between law and fact incredibly, almost impossibly blurry?
It is remarkably blurry. It is a legal tightrope, and that is exactly where we find ourselves today. This blurry line is the new bloody frontier of American administrative law. Every single major lawsuit over a federal regulation going forward is going to start with this exact battle.
So the government lawyers will walk into court and argue, Your Honor, this regulation is based on a technical question of fact and procedure. Therefore, under the 7-county precedent, you must grant a substantial deference.
And the corporate lawyers will walk into the exact same courtroom and argue, no, Your Honor, this is fundamentally an interpretation of statutory law. Therefore, under the Loper Bright precedent, you must apply independent judicial review and strike it down.
Which brings this entire epic story full circle. Deference isn't entirely dead. It was violently evicted from the front door of statutory interpretation, but it survived. It retreated, dug in, and set up camp in the highly specific procedural corners of the law.
It sets up an incredibly complex, highly localized legal landscape for the future. It means that whether a vital national regulation survives or falls isn't going to be based on a single overarching predictable doctrine like Chevron anymore.
No more easy answers.
No, it is going to be a grueling trench warfare, case-by-case analysis of exactly what kind of statute is being applied, what kind of specific textual authority was delegated by Congress, and whether the judge categorizes the issue as a matter of law or a matter of fact.
So let's summarize this incredible journey. We started in the economic anxieties and stagflation of the early 1980s.
Right.
The desperate desire for economic growth created the Chevron bubble, this pragmatic idea that if a law is vague, the executive branch expert should be trusted to make the call. We watched that legal bubble grow for 40 years, flipping from a deregulatory tool into a massive, impenetrable shield for the modern administrative state.
Then, in 2024, a group of Atlantic herring fishermen, burdened by a staggering $710 a day fee to pay for their own regulators, took a needle to that massive bubble and popped it in Loper Bright.
They reclaimed the power of the judiciary to interpret the law independently.
And now, as we look at the landscape in 2026, we are living in a highly scrutinized, chaotic reality. Judges, rather than agency scientists or bureaucrats, are the ultimate arbiters of what our laws mean.
We see agencies desperately trying to navigate this new, hostile terrain, shifting to guidance documents, leaning on Skidmore persuasion, and fighting bitter courtroom battles over whether something is a question of fact or law.
And we see the political branches utilizing this exact chaos to rapidly dismantle decades of environmental and labor rules.
And this touches your life directly. This isn't just abstract theory. Whether you are running a small business trying to navigate the complex compliance rules of the IRS, or you're a consumer looking to buy an e-bike and wondering if the battery safety standards are actually enforceable, or you're simply someone breathing the air downwind of a massive power plant, the invisible gears of how the rules governing your life are made, interpreted, and enforced have been fundamentally swapped out.
The noise of this shift is happening in federal courtrooms and legal briefs, but the impacts will be felt quietly and profoundly in your daily life for decades to come.
Which leaves us with one final, lingering thought to mull over as we close this out. As we look to the horizon, toward the rapid exponential rise of artificial intelligence, the mind-bending breakthroughs in synthetic biology, the dawn of private commercial space exploration, we are entering an era of unprecedented technological complexity.
We really are.
If Congress, which is structurally designed to be deliberative and slow, remains slow to act, and if expert regulatory agencies no longer receive the benefit of the doubt when trying to apply old, outdated laws to these entirely new paradigms, who is going to step up to write the rules of the future?
It's a huge question.
Is our judicial system, relying on independent judgment and 18th century tools of legal interpretation, truly ready to become the nation's chief scientist? Thank you so much for joining us on this deep dive. Keep questioning the invisible architecture of the world around you. We'll catch you next time.